Bonjour et bienvenue tout le monde. I call this meeting to order. Welcome to meeting number 22 to the House of Commons Standing Committee on National Defense. La réunion d'aujourd'hui se déroule sur...
Today's meeting is taking place in a hybrid format pursuant to the House of Commons Order of January 25th, 2021, and members will be speaking in person or over Zoom. The deliberations will be published on the House of Commons website. For your information, webcasting will show the person speaking rather than the committee as a whole.
If interpretation is lost, please inform me immediately and we'll ensure that the interpretation is properly restored before resuming the proceedings. Before speaking, please wait until I recognize you by name. If you are on video conference, please click on the microphone to unmute yourself. A reminder that all comments by members should be addressed through the chair. And when speaking, please speak slowly and clearly. And when you are not speaking, your mic should be on mute. With regard to the speaking list, the committee clerk and I will do the best we can to maintain a consolidated order of speaking for all members, whether they are participating virtually or in person. Okay. All right. Before we introduce our witnesses for today, there are two issues I'd like to bring to the committee's attention. The first is the law clerk has completed his review of the documents pursuant to the production order issued by the committee on Monday, the 8th of March. We received a letter from the law clerk this morning. I'd like to bring to your attention the following extract, and then I will be asking for your guidance from the law clerk letter. And it reads, I quote, "In the course of our review, we noted that certain records contain sensitive personal information that does not fall within the categories of redactions expressly allowed by the committee's order. My office has highlighted this information in yellow in the documents for the committee's consideration should it wish to redact that information before distributing the documents or making them public." So we can actually give him permission to do this, or we can distribute them with certain guidelines about the confidentiality of the information that is included in these documents. Does anyone have a significant preference? Go ahead, Madame Gallant.
Well, I would like to see the documents with your encouragement that they remain confidential up to a point. Like, I don't want to have anything redacted. We've already have too much redacted.
Okay. All right. Anyone else would like to? Can I get my gallery view? All right, thank you. Thank you. That's better. I see you all now. This is good. Go ahead, Madame Vanderbilt.
So if you could perhaps clarify, Madam Chair, or perhaps the clerk could clarify the documents. What you're asking the committee is to send the documents to committee members with highlights from the law clerk saying these are things that are sensitive and personal and should not be sent publicly. And then we as a committee would then, it would behoove us, I would imagine, if we plan to make it public or distribute further, we would then make sure that those ones highlighted by the law clerk are redacted before we then further distribute, but members themselves would be able to get the unredacted version. Is that what the law clerk is suggesting? Perhaps the clerk could clarify.
that's what the clerk is asking, the law clerk is asking the permission to redact those. But we can also not redact them, but then it's the responsibility of the individual members to treat that information confidentially. Okay, so
And-
that's the option.
So in that case, I would suggest that as long as we sort of get a nod of heads from members that we would then treat the personal information confidentially, it would be fair to give that to members, knowing that members will be discreet with that information. I think that's the fair and transparent thing to do, I would imagine.
Okay, Mr. Bazan, go ahead.
And I just want to agree with the parliamentary secretary that I think that, if we have the areas that are highlighted that are sensitive and that we stress upon all members of the committee that part of those documents are not shared, that is held in confidence by committee. I think that if that's clear to everyone, and the rest of the documents, which we know some of these have already been made public, that are then more free to use as we see fit. But protecting the private and confidential matters that are contained within those documents, so as not to taint the investigation.
Okay, copy. Madame Gallant, did you?
Yes, I would like to see the documents before we agree in advance to anything. And then based on what Mr. Bazan said, I think the committee will take the proper course of action.
Well, I think that's what that's what I'm getting the impression that we're saying we will send the unredacted, that we will ask the clerk not to remove those portions. We will share them with the committee members, and then the committee members must commit to the recognition. The parts of the documents that are highlighted in yellow are confidential. And so it just must be treated respectfully. All right. All right, so that's the direction I'll go back to the clerk with, and you will see that being sent out to you probably later on this afternoon. All right. Okay. The other issue is about the order that came out of the House last evening for a witness to appear on the 6th of April. We're currently working on that issue at the present time. So I would plan to keep your schedule free on the 6th of April, and we will let you know as soon as we have the details. I would also suggest that perhaps it might be the same day we should do our steering committee meeting rather than doing days apart. We do everything we need to do on the 6th and do our steering committee on the same date. Anybody want to weigh in on that? Go ahead, Mr. Bazan.
Actually, Anita had her hand up before I did.
No, I just have a question for the clerk. It's on another issue.
Okay, so just on that then, Madam Chair, is I'd say instead of just doing a steering committee, let's do the entire committee, since we're all going to be online anyway, and let the entire committee talk about what we want to do as work. So just saves one step. If the committee approves it right then there, it doesn't require us to have a steering committee report to take it back to the whole committee and then have that approved down the road. So we can actually get moving forward on organizing our work accordingly. But I do agree if we can have Ms. Estrada show up on the 6th. And then the other witness would be, of course, the motion to have Gregory Lick appear, the military ombudsman. And if we can have that happen maybe at the same time, or we have to do it next week, then we do it next week.
All right. Go ahead, Madame Vanderbilt.
Yes, on that, just going back to the discussion we've had about naming witnesses, private citizens in a public forum, which then puts them on the spot in terms of explaining why they did or didn't accept the invitation. I would just suggest that be an in-camera meeting. Okay.
I'm good with that.
Are you good with that? Okay. All right.
Yep.
So we will organize then a type of steering committee with the entire committee in camera to discuss about how we move forward with this particular study and our work plan going forward. Is everyone on board with that? Okay, good. Right, I think that's all I need to deal with right now. Oh, Madame Vanderbilt, go ahead.
Actually, it's just a question for the clerk. I had put a notice of motion to bring Richard Fadden, who was the former National Security Intelligence Advisor in 2015 to the Harper government. I just want to ask the clerk, did I get 48 hours notice in when I put that in? I did not. Okay, then in that case, I won't move that motion until the meeting that we're planning on the 6th.
I was okay with you moving it, and then you got our support.
Okay, but I won't move it because I want to be consistent with my feeling that this committee should give 48 hours notice when we're going to be putting motions. So I'll wait till next week.
All right, thank you, Mr. Baker.
Thanks, Chair. Just a point of clarification, that April 6th meeting, do we know when that time would be of the meeting? I'm just asking because it's a
Yeah, pursuant to the order, it needs to start at 11, so we could have our steering committee either before or after. Okay, maybe before. Might be a good thing to do.
Okay.
Madam Speaker, some of us are on the West Coast, so no, meeting before. Committees have agreed not to meet at 7 a.m. Pacific time.
All right, Mr. Garrison, you are correct. All right, okay. So we'll do our steering committee meeting afterwards. All right, any other contributions on this discussion? All right, good. Well, thank you very much. We have a part plan going forward. Okay, so thank you to our witnesses for being with us today and your patience where we got a couple of the details that needed to be ironed out done. Pursuant to Standing Order 1082 and the motion adopted by the committee on Tuesday, February 9th, 2021, the committee is resuming its study of addressing sexual...
Point of order, no
point of
sound.
order.
Sorry?
Chair, we couldn't hear you. We can hear you now, but we couldn't hear what you just said.
Okay, thank you very much. Thank you for speaking up. We are resuming our study of addressing sexual misconduct issues in the Canadian Armed Forces, including the allegations against former Chief of the Defence Staff, Jonathan Vance. With us today by video conference, Madame Janine Sherman, Deputy Secretary to the Cabinet, Senior Personnel and Public Service Renewal at the Privy Council Office, and Lieutenant Colonel Retired Bernie Boland. Up to 6 minutes will be given for opening remarks. Welcome, Madame Sherman and Mr. Boland. I'd like to invite Madame Sherman to begin with her opening statement, please.
Thank you, Madam Chair, and members of the committee. I thank you for the opportunity to appear again today before you, following on my appearance from February 19th alongside the Deputy Clerk of the Privy Council. Je suis sous-secrétaire du cabinet.
I have been the Deputy Secretary to the Cabinet for Senior Personnel and Public Service Renewal since May 2016. Prior to that, I was Assistant Secretary to the Cabinet for Senior Personnel. And that is a position I held since October 2014. As Deputy Secretary to the Cabinet, my responsibilities include advising the Prime Minister and Cabinet on Governor and Council, or GIC, appointments. The Privy Council Office supports the government in circumstances where issues arise with GIC appointees. In doing so, we provide independent, nonpartisan advice and support to the government. When there is evidence of inappropriate conduct on the part of a governor in council appointee, we provide our best advice to the government on how to address the issue.
In my previous appearance before the committee, I felt it was important to protect the confidentiality of my discussions with the former Ombudsman for the Department of National Defence and the Canadian Armed Forces, and the integrity of the Ombudsman's office and its processes. Since that time, the committee has heard a number of witnesses and further information has been presented. With certain details having been shared by the former Ombudsman, I can confirm that in early March of 2018, the Clerk of the Privy Council asked that I follow up on an issue that the Ombudsman had raised with the Minister regarding potential allegations of misconduct against the Chief of Defence Staff. I was asked to follow up immediately, which I did. A follow-up exchange of emails between myself and the former Ombudsman took place March 5th and 6th. And in those exchanges, I did explain that I was seeking to better understand in order to provide advice to the Minister in the context of his role in supporting the Prime Minister and the Governor in Council on appointments. I met with Mr. Walburn on March 16th. In my email exchanges and in my meeting with Mr. Walburn, I did not receive information upon which to take further action. Madam Chair, on the specific issue the committee is studying, given that the Canadian Forces National Investigation Service has opened an investigation, I am limited in the responses that I can provide in order to respect the integrity of the investigative process. Protecting the confidentiality and the integrity of any investigative process is critical in ensuring that individuals feel safe to come forward and that we respect their privacy. I know that we all agree that any instance of harassment is unacceptable. Every situation is unique, but the right to a safe workspace where individuals are treated with respect, with dignity, and fairness applies to everyone working within a federal workplace. As a senior member of the Federal Public Service, this is a fundamental focus for me in carrying out my responsibilities. Once again, I thank the committee for the opportunity to appear before you today. I would be pleased to answer any questions you may have to the best of my ability and within the limitations that I have noted. I can also provide information of a general nature regarding PCO's role in the management of GIC appointees, should the committee wish. Thank you, Madam Chair.
All right. Thank you very much, Madame Sherman. And over to you, Mr. Boland.
Madam Chair, thank you for this opportunity to testify. I'm Bernie Boland, a retired Lieutenant Colonel who served honorably in the Canadian Armed Forces for over 30 years. And for the past 12 years, I was an engineer in the public service. I retired on 30 December 2020. I'm testifying because DND has demonstrated an inability to act in an independent judicial fashion that honors due process, defends procedural fairness, and respects the rule of law. In 2016, I reported wrongdoing and misconduct when an employee I had the privilege of supervising requested I report her harassment and human rights violations by a senior engineering manager. As compelled by oath and code of values and ethics, I reported it. Her case is now at the Canadian Human Rights Tribunal awaiting adjudication on discrimination and deferential treatment due to age, gender, ethnicity, and being a Muslim. Once I reported, everything in the workplace changed. I faced reprisal and retaliation. I was silenced, denied due process, and my procedural fairness rights withheld. To date, external to DND, I have submitted to the Federal Court of Canada an application for judicial review of DND's grievance dismissal, given notice to the Registrar of the Canadian Human Rights Tribunal to be a party to a tribunal hearing, and filed a complaint with the Ministry of Labour on DND's breach of my Bill C-65 rights. Internal to DND, I've submitted formal complaints and grievances, all to no avail. Also, I provided to the Deputy Minister detailed analysis of the lack of due process, procedural fairness violations, conflict of interest, and decision maker bias. Additionally, I provided to both the DM and Minister Sajan independent analysis, the Lowry report, from a retired RCMP fraud investigator that confirmed and corroborated decision maker bias, conflict of interest, denial of due process, and violations of procedural fairness. It was ignored. However, because I reported the harassment and human rights violations of the employee I supervised, DND secretly, in a formal departmental submission to the Canadian Human Rights Commission, made me the scapegoat to exonerate those responsible and culpable. This D&D submission was made without my knowledge and with no opportunity to defend myself. It was condemnation without any representation. Once I became aware of D&D's secret scapegoating submission, I formally complained because the Director General of Workplace Management secretly made me the scapegoat. Troy Crosby, Assistant Deputy Minister Materiel, determined that it was proper conduct for the DG to secretly make me the scapegoat, and Jody Thomas, the DM, condoned D&D's secret scapegoating of me as proper departmental conduct. Without any investigation, D&D dismissed my complaints. I also submitted a grievance and a request for an independent ethical review on the myriad conflict of interest, bias, denial of process, and withholding of procedural fairness rights. D&D similarly dismissed these. D&D's justification, as stated by Assistant Deputy Minister Human Resources Civilian, Mr. Choi, is Mr. Boland speaks to not having an opportunity to defend himself. It is to note that it is the parties to the CHRC complaint, the D&D and the complainant to the CHRC, who are entitled to procedural fairness rights. The D&D, as a respondent to the CHRC complaint, has no responsibility to gather information from all potential witnesses. This is the responsibility of the CHRC appointed investigator. The conduct is therefore not considered improper. The complaint pertains to a single matter and does not meet the threshold for a severe incident. It will not be investigated. The CHRC submission is a protected document. Mr. Boland does not have access rights to the submission, and therefore Mr. Hui could not have reasonably known that it would cause offense or harm, nor can it be considered directed at Mr. Boland. Mr. Choi's justification makes it unequivocally clear to me that D&D will not act in a procedurally fair fashion. D&D takes no responsibility to ensure human rights are fulsomely and truthfully addressed in D&D by D&D. D&D considers it proper to secretly make those who dutifully report misconduct the scapegoat for the misconduct they report. Despite their zero tolerance policy, D&D will unilaterally and arbitrarily dismiss misconduct to excuse their obligation to investigate it. And D&D believes institutional secrecy absolves their wrongdoing. Since 2016, in my effort to be heard, have due process applied, and be treated in a procedurally fair fashion, I have formally engaged many, including the Prime Minister, Minister Sajan, my Member of Parliament, Pierre Poilievre, the Minister of Labour, and the Ombudsman. Despite these efforts, D&D refuses to honor their commitments and render due process and respect for the rule of law. On 1 January 2021, Bill C-65, Workplace Harassment and Violence Prevention Regulations came into force. The Deputy Minister assigned Mr. Choi coordination and implementation responsibilities. Mr. Choi violated my rights enshrined in this legislation by denying my right to an investigation. On the advice of my legal counsel, I requested the Minister of Labour restore my rights and remedy this breach. I've yet to receive any acknowledgement from the Minister of Labour. Thank you, Madam Chair.
All right, thank you very much, Mr. Boland. And now I will open the floor for questions. Up first, Mr. Bazan, please.
Thank you, Madam Chair, and I want to thank our witnesses. Colonel Boland, thanks for your service, and thank you for coming forward, outlining the disturbing culture within the Department of National Defense that we thought we were only dealing with at Canadian Armed Forces, but it seems that there's cover-ups happening at the department, and we'll be asking questions of you later on in the committee. But I want to concentrate on asking questions, Madam Chair, to Ms. Janine Sherman. Welcome back to committee. Now, you said in your opening comments that you did not receive information upon which to take further action back in March of 2018. So I suspect that you'll have lots of latitude in answering the questions that we have for you today, since you never found anything, in your opinion, that was warranted an investigation in 2018. So can you tell us, Ms. Sherman, exactly who told from the Prime Minister's office, instructed Privy Council office, because you said it was Michael Warnick, who's the PCO or the Privy Council clerk at that time, that asked you to meet with the ombudsman. So who told you and Mr. Warnick to follow up with the allegations about General Vance?
Madam Chair, okay. Thank you. Well, I think the information that has been, I'm not sure that you have seen the emails between myself and the people that were involved have been released through access to information, and that information is redacted as personal information,
Okay,
not
so
a public servant.
So I do see the email here on Friday, March the 2nd from between you and a redacted person. I assume that was with Mr. Walborn at the time, or was that a different individual?
The email exchange on March 2nd
Yes.
Was not Mr. Walborn.
It was not Mr. Walborn. Okay, and it was not somebody else within the Privy Council office or in the minister's office?
All I can say is that it was not a public servant, because the information that is redacted because it is personal information.
So when you
Under the sorry.
Yeah, so when you made the decision to reach out to Mr. Walborn, did you tell Mr. Walborn why you wanted to meet with him?
Yes, and as I mentioned, the clerk of the Privy Council had asked me to follow up on the information that Mr. Walborn had raised with the minister. And so I did follow up with Mr. Walborn in that context.
Okay, so between March the 2nd, when you reached out to Mr. Walborn, as well as the other email conversation that you had, who else within the minister's office, the prime minister's office, and the PCO did you talk to before you met with Mr. Walborn on March the 16th?
Well, that is the information that is personal information at this point in time. I am not able to comment on who those people are. I worked through the clerk, my boss, in terms of our next steps that we would take.
You know that in this study, we do need to know some details about who knew what within the department, within the minister's office, within the prime minister's office, and within the PCO. I don't believe that to say that those are personal confidential discussions when it involves, as you describe them, as a GIC appointee, but we know that means General Vance, as well as the ombudsman, Gary Walborn, who is also a GIC appointee, that those discussions should be made available for public record. And that's why we asked for the production of documents so we can get to the bottom of who knew what. So who drafted the memo for you that you used as your briefing note for your meeting with Gary Walborn on March the 16th that has been made publicly available?
Thank you, Madam Chair. That first, if I maybe could clarify one point. In those emails, when I refer to a GIC appointee, and as you've pointed out, it was now known to be the Chief of the Defense Staff. The emails are crafted, at that time with respect for the confidentiality of who we may be speaking about. And so that's the reason the Chief of the Defense Staff is a GIC appointee, and it is done out of respect and confidentiality in terms of just the communication with the Ombudsman. And so the note that you refer to was prepared here in my office by my staff.
Okay, so just so I'm clear, on all these redacted documents that came up, the redacted portions aren't necessarily the name of the victim. You're saying that this is to protect the confidentiality of political staffers.
No, if I may, I think the those redactions were made in the under the construct of the Privacy Act and the Access to Information Act. And so personal information does not apply to a public servant. That those names of public servants are not redacted. And I'm in the interest of
Okay, stand by.
Trying to be helpful.
We lost you there for just a minute, Madame Sherman.
Okay.
Could you
Sorry.
start this answer over again, please?
And please reset the clock.
No.
Okay. So in terms of the redactions of the names, can you hear me okay?
Yes.
Okay. It is, those redactions are done on the basis of the statutory requirements in the Privacy Act and the Access to Information Act. So public servants' names are not redacted. Non-public servants, that does constitute personal information, and that is the reason that is redacted. In the interest of being helpful, I would like, I guess I could, in a generic way, indicate that those interactions were between myself and people in the Prime Minister's office.
Okay, I appreciate that very much. Thank you. Now, you made the decision alone or under consultation with others not to pursue an investigation and not to refer this to the National Security Advisor.
So as a matter of course, Madam Chair, in my responsibilities, I would not make a decision alone in that respect. I did meet with Mr. Walborn myself, and after that discussion would have briefed up to the people that had been involved in the discussion to pursue and try to get more information about the generality of the complaint. So I would have done a follow-up in terms of certainly the clerk.
So that would have been up to
Right.
Michael Warnick, who was the clerk at the time, but most likely as well to Katie Telford, the Prime Minister's Chief of Staff.
I am not in a position to, I think I have shared information to say it was within the Prime
All right,
Minister's
thank
office.
you very much. Time, even extra time, is up.
Thank you.
On to Mr. Bagnall, please.
Thank you very much, Madam Chair. And I just wanted to start by acknowledging it's Purple Day to enhance the understanding of epilepsy. And thank you to the witnesses for coming. It's very helpful, both of you, to help improve our understanding, improve the processes at DND. Ms. Sherman, I just wanted to, I have a couple of questions for you, but I just want to make sure, as you mentioned, that you don't, in the answers, don't say anything that would jeopardize the ongoing investigation. But in a general sense, could you just let us know what the process PCO follows when there's allegations of any type of misconduct that are brought against one of its GIC appointees?
Thank you for the question, Madam Chair, and I would be happy to provide some background in terms of the processes that we use. First of all, I think the process is always dependent upon the nature of a complaint. Our role in the Privy Council office is to provide advice to decision makers throughout a complaint process that involves a GIC appointee. As I've mentioned, every case is unique and our advice has to take into account the specifics of a circumstance. But there are four main principles that really underpin our approach. That is a respect for procedural fairness to all parties, supporting investigations that are independent, fair, and free from bias, safeguarding personal information of all of those implicated in accordance with legislative frameworks, and notably, as I've mentioned, the Access to Information Act and the Privacy Act, and respecting the confidentiality of the advice that we do provide back to ministers and to the government of the day. So, in general terms, when we have information to provide advice on an issue that is related to the conduct of a GIC appointee, we base our advice on those legislative and policy frameworks that govern workplace well-being. We could, depending on the nature of the issue, the specific case, ending a course of action that would be an administrative review. It could be referral to a independent third party for investigation, or we could need to refer the matter to the appropriate police authorities, whether that is local police, RCMP, or the CFNIS. It all depends on the nature of the information that is brought forward. So I think the if a complaint comes forward that falls under the purview of the new workplace harassment and violence prevention regulations, which did come into force in January of this year, we would provide advice to our colleague on how best to address the complaint under that policy and legislative framework. Our role is really providing advice to decision makers and the officials that are overseeing the complaint at various stages throughout the process. So at the initial stage, we can advise on, on best practices for determining whether an occurrence that was described in the complaint meets the test for the definition of harassment, and that is set out in the Canada Labour Code. If the complainant, the principal party, requests an investigation, we can then advise on ensuring due process. For example, ensuring that the complainant and the responding parties are able to review draft portions of the draft report in a way that protects the appropriate level of confidentiality. We would also advise officials on the steps that will follow upon the conclusion of an investigation, and in terms of assessing the findings and providing advice to a decision maker. So we do that in support of what the outcome would be from the investigation, and then we also provide advice for the Governor and Council at the conclusion of a complaint process. And that could range from a recommendation to take remedial actions, training and development, for example, or potentially a recommendation for removal if the findings of the investigation are such that the appointee has lost confidence of the Governor in Council. So I hope that answers your question. Thank you.
Yeah, that's very helpful for all of us to understand the process. I wonder if there's anything more you could share to us about any more information on the meeting you had in March with the Ombudsman, or the email exchange that you mentioned in your opening remarks that you had with him on March 5th and 6th.
May I, Madam Chair? Yes. Thank you for the question. I think I would, you've seen the emails. I think the important thing to notice is that in my exchange, the former ombudsman was clear that the information he held was being held in confidence, that he had presented options to the complainant, and he was awaiting further direction based on whatever they determined to do. He would act in respect of that direction. So we knew that I knew in meeting with him that he had provided a complainant with some options and courses of action that could be taken. So and I think in my emails to him, my efforts were not to get in the way of a process that his office may wish to pursue on behalf of the complainant, but to find out more about the nature of the complaint so that we could provide some advice in the context of my responsibilities around supporting the Prime Minister and the Minister in respect of managing a GIC appointee.
All right, thank you very much, I'm afraid. Monsieur
Okay.
Barcelou-Duval, s'il vous plaît.
Oui, merci, Madame la Présidente. Madame Sherman, dans votre allocution tout à l'heure, vous avez mentionné que après avoir...
Madam Sherman, you mentioned in your opening statement that following some discussions with Mr. Walborn, the Ombudsman, that you contacted once you were made aware of the situation, you did not note any aspect that would require you to go any further in an investigation. So does this mean that the concerns Mr. Walborn had were not well founded?
Thank you, Madam Chair. I would not make any pronouncement, I think, based on my conversations with the former ombudsman as to how well-founded the complaint may be. The point to be taken from my conversation with Mr. Walborn on March 16th was that he did not provide information which would have enabled us in our role to take further action.
Merci.
Thank you. My understanding was actually that from your perspective, you had tried to determine the identity of the individual, of the victim per se, and that Mr. Walborn had wanted to protect the identity of this person. Would that not be the reason why you decided not to go further? Because he didn't want to tell you who it was?
Thank you for the question, Madam Chair. I would say that is not correct. My exchange with Mr. Walborn made it clear that I was not seeking confidential information. I was not trying to determine anyone's identity. It was to see if we could have information about the nature of the complaint.
Okay.
Okay. Did you contact General Vance regarding the situation? Did you have any discussions with him? Did you speak to him?
In response to that question, I think that the indications from the exchanges of emails and the what I have said about our conclusion from that discussion was that there was no information provided that would have enabled further action to be taken.
Donc,
So you did not discuss the situation with General Vance, that's what I gather, because you, from your perspective, there was no information requiring any further action.
Thank you for that question. That is correct. There was no information that was provided that would have enabled us to take further action. I think that the other element to be conscious of was the confidentiality of the information that the ombudsman held. He indicated, certainly in the email exchanges, that was of paramount importance. He would not proceed with any actions unless he had written consent from a complainant. And therefore, I was not in a position to share any information. And I didn't have and because of that confidentiality, I should clarify, he did not provide information that would have enabled us to take further action.
okay.
Okay. And I gather that you did a follow-up with the minister also?
As I have mentioned, my responsibilities was in respect of the Privy Council office, and I did return to the clerk with the outcome of my conversation with Mr. Walborn.
Lors de votre...
In your testimony from February 19th, you had remained you were rather vague And while there was something about the allegations and you not wanting to interfere in the investigative process, I'm having a hard time with this, is that you were saying that you didn't have information allowing you to go any further with this, but the information that was given to you by the ombudsman, it seemed to be serious. Did it seem credible?
Thank you, Madam Chair. As I have mentioned, the outcome of my conversation with the former ombudsman was that we did not have information on which to take further action. And I cannot therefore make any comment about whether I did not have information about the nature of the complaint. Now, I think, and I'm sorry, could I ask you to repeat there was two parts to this question.
Oui, est-ce que...
Yes, one was what the ombudsman said, was that credible and was it serious? Did you consider it to be credible, serious, reliable?
Thank you for that clarification, Madam Chair. We were doing the follow-up because we take concerns being raised seriously. We always do. And so I think by virtue of the fact that we sought to speak to the ombudsman to better understand whether there was information that could be shared outside of confidential information that would enable us to take further action. I was not provided with further information at that time. I would also, I think, want to maybe just loop back to your comment about being vague. The information in 2018 was we did not have that. We did not have information. The ombudsman had information, and as I've mentioned, he was clear that it was provided on a confidential basis.
Thank you. Madam Sherman, what I want...
Trying to let that go for a little bit, but on to Mr. Garrison, please.
Thank you very much, Madam Chair. I want to start by echoing the thanks to retired Lieutenant Colonel Boland for being with us today and the unfortunate task that he's had to take on in corroborating the culture within both the Canadian Armed Forces and DND, which appears to have been not zero tolerance, but willful blindness toward complaints of sexual misconduct. And I'll return in my next round to him, but I want to stay with the Privy Council office here. Let me start by saying, Ms. Sherman, I take no pleasure in having to question you in committee, but the committee was left with little choice since both the Minister and the Prime Minister referred to your office as an independent investigating authority and actually directed our questions to your office. So I would much rather have had a more fulsome explanation by the ministers responsible. So the question I have for you to start with is, the military ombudsman came to you saying, I have seen evidence that is and requires an investigation of General Vance on the grounds of sexual misconduct. Why do you need to know more than that before you would launch not you personally, but you would see that an investigation was launched?
Thank you, Madam Chair. The Ombudsman went to the Minister, as I think has been described, and I was asked by the Clerk of the Privy Council to follow up on that conversation. I did not have specific information, and that is why I sought to meet with the Ombudsman to follow up on that and to try and understand the nature of the complaint, and respecting the fact that he was clear that the information he had was given to him in confidence, that the complainant had not provided any permission or direction on how they wished that complaint to be managed.
But with respect, Ms. Sherman, you're doing the same thing that the minister did. You had evidence that there was a well-founded complaint of sexual misconduct against the chief of defense staff, and neither the minister, and then it turns out your office, did any investigation or took any action. Instead, General Vance remained for more than 3 years as a chief of defense staff, and we now know there are additional allegations of sexual misconduct being investigated. So I just fail to understand how that wasn't sufficient. Second question I have for you is, did the question of national security come up in the discussions of these complaints? Because it's quite clear as Chief of Defense Staff, General Vance would have held the highest security clearances possible and was in a very sensitive position. So anyone who is being accused of things like sexual misconduct perhaps has their ability to act compromised. So was there a discussion in any of these documents or between you and the clerk of the Privy Council of the issue of national security and the threat to national security that these kind of complaints present?
Thank you for that question, Madam Chair. A couple of clarifications in that I did not have information of a well-founded investigated complaint. Indeed, we were
I'm going to stop you right there, Ms. Sherman. I want to stop you right there because what you're doing right now is questioning the credibility of the military ombudsman. When you say that, you say he has no credibility as the military ombudsman. Is that your intent today?
Thank you for that question.
He came to you and said there's a well-founded complaint.
If I could clarify that, it is not my intent in any of my comments today to discredit the former ombudsman. In fact, our respect for his office and for his mandate and for his ability to manage the complainant and their wishes in regards to confidentiality and how next steps should be undertaken is what we focused on. So my concerns, Madam Chair, was simply to clarify that I did not have a complaint that, to my understanding, had been investigated or that there was an undertaking to do an investigation at that stage back in March of 2018. And our purpose was, because we take the safety and security of the workplace to heart, that this is a very important fundamental responsibility we have, and that we do, in fact, want to make sure that the conduct of GIC appointees is looked into, that we tried to get information that would help us to determine what those next steps were. Our role in the Privy Council office and my role in supporting the Minister and the Prime Minister and the government in terms of the managing the conduct of GIC appointees where an issue has arisen is to provide advice and some counsel on what next steps could be taken. And that was our objective in terms of trying to understand what information the Ombudsman could share that would be consistent with his responsibilities as Ombudsman and in protecting the confidentiality of the person who had raised some concerns and an allegation that we did not have information about.
So when presented with what I still will assert was the Ombudsman telling you there was a well-founded complaint on sexual misconduct, did you open the file, so to speak, of General Vance, and did you have access to the fact that he had been previously investigated on the basis of similar allegations?
Thank you for the question. I cannot speak to the specific information about General Vance. That would be personal information. As I have said, we do take concerns that are raised very seriously. It is something that we did not, at the time of my conversation with the Ombudsman in March of 2018, action. But it was something that we had to think about and be aware of, definitely. And that is why I reported back to the Clerk of the Privy Council about the fact that we did not have information that would enable further action at that time.
All right, thank you very much. On to Madame Alislev. And Madame Sherman, could I ask you to check on your computer and make sure you don't have too many apps open? Because sometimes there's a little cutout So give that a try and we'll see if that solves the problem.
Okay,
Merci
thank you.
beaucoup. Okay, Madame Ellislev.
Well, thank you very much, Madam Chair. And thank you to both the witnesses for being here. And I'd like to direct my questions to Lieutenant Colonel retired Bernie Bolin. I'd like to ask, you were in the Air Force, but currently and throughout the process that you've described in your testimony today, you and all of the other people to which you refer were civilians. Is that correct? Did we lose him? There you are.
Madam Chair, yes, they were all civilian at the time. A number were retired military personnel, though.
And this whole process has been going on since early 2016. Is that correct?
Late 2016, the various conflicts were brewing in our organization from early 2016 onward.
Wow. Could you explain to us how you ended up having to bring it all the way to the Defense Minister's Chief of Staff and what involvement he has had?
I brought it there because I was going to be diligent and make sure my issues came forward. I wasn't going to be satisfied to be silenced. I literally walked in to the office, presented him with documentation, had him sign for the documentation that I was providing. I sent him emails and provided him information, documentation to clearly express my concerns, what I was dealing with, and transparently as possible reflect what was occurring to me, what wasn't occurring to me, denial of due process, my procedural rights failing.
Did he say that he would advise the minister?
I explicitly asked him to do that, and I staffed complaints directly to the minister using his name. And I sent correspondence by email to the minister's parle.gc.ca email address.
And by doing so, you made him aware that D&D officials, including the deputy minister, were aware of and had been engaged in not overturning the false report that was authored and sent on D&D letterhead to the Human Rights Tribunal. Is that correct?
Yes, I complained about that I was being scapegoated, explicitly being blamed for the human rights allegations that I reported. And I had, as I said in my opening testimony, no opportunity to defend the allegations made against me. It was done secretly. And the only reason I was made aware of it because the individual that's in front of the Canadian Human Rights Tribunal now disclosed that information to me and asked me if I was aware of it.
And what was her reaction to finding out that they had blamed you rather than the person that she had filed the complaints against?
Well, I think she was outraged, but not surprised.
And the reason why this is so serious in your mind is that D&D put a document to the Canadian Human Rights Tribunal as a representative of an objective, professional, and truthful document with the weight of D&D behind it to an outsourced organization that in fact contains false and prejudicial information about you.
Absolutely. And in my complaint about this up the chain, I made that explicitly clear. I'm sure the expectation of any outside agencies such as the Canadian Human Rights Commission expects of a large organization like DND to provide vetted, verified, and legitimate validated data.
And you made everyone in the chain, ADM Matt and DGs and the deputy minister herself, and there's documentation signed by the deputy minister back to you. Is that accurate?
Yes, I had several letters that came back and spoke about due process. So there's many different documents. The deputy minister, for the most part, didn't respond to things that I sent her.
But she did acknowledge through her signature that she is aware, even though she didn't respond to the substance of what you were asking her to respond to. She made a response, just not an answer to what you are asking her to respond to. Is that correct?
Her response is basically to me ended when she responded to my MP on my behalf, Pierre Poilievre,
Thank you.
in
Okay. And then last, this must be incredibly stressful on you. Can you just give us a bit of an idea? Have you had any support? How much work has this been? What kind of toll has this taken on you when you were the one who sought to look after the person who reports to you and to do the honorable and right thing to try to stop this kind of behavior in the Canadian Forces?
I've had absolutely no internal support by DND or anybody. As soon as I brought this up, I was ostracized. My employment was threatened initially. Disciplinary measures were recommended. I received a letter of expectation. I moved on from that employment site. Fortunately, I was able to find other work in DND. The toll this has taken, we're only midway through. Right now, I am proceeding to the federal court to have things addressed, to actually find opportunity, to actually have my voice heard by a judicial body that will actually allow me due process and a chance to advocate for my position and represent myself. None of that was provided in DND.
So
all right,
doing
thank you
what
very
is
much.
right.
On to
Thank you very much.
Monsieur Robillard, s'il vous plaît.
Thank you, Madam Chair. Good day to the witnesses. Thank you for being here with us today before the committee. My question is for Mr. Sherman. Ms. Sherman, just to clarify one final point again, did the Ombudsman provide you with information that would have allowed you to carry out an investigation on the allegations against Mr. Vance, General Vance?
Thank you for that question. No, and he did not provide me with any documents, information at all. We had a conversation. It was based largely on the emails that we had exchanged in terms of the importance of the confidentiality and how that was a responsibility of him and his undertaking to the complainant that had come forward. And so he did not provide me with information, with documents, with anything in that respect.
Lui avez-vous demandé de faire?
Did you ask him to do anything, as in ask for the consent of the survivor or share information that would have allowed you or other officials from PCO to bring that investigation further?
Thank you for that question. I think, and I want to be careful in terms of the information that I can share. I'm trying to stay within the confines of the information that is available through our email exchanges. The conversation that we did have remains. I think it's important to keep that confidential. I would say, though, as a matter of course, and as I think the ombudsman's emails indicate, that the concern for the complainant who has come forward is paramount. And so in these kinds of situations, and I think as I have described a little bit about our role in PCO in terms of providing advice and looking at the process and the way forward, that it would not be unusual for me to offer support in any way that we could, in terms of whatever direction the complainant provided to the ombudsman, and that if there was, as someone that is concerned and responsible for the conduct, for managing the issues that arise in the conduct of a GIC appointee, that we would want to be supportive and available should there be any information that could be shared. So that is a general principle in how we would approach those kinds of conversations.
Did you think of the information? What did you do with this information? And if that information provided had been complete, what would have been the procedure that needed to be followed?
Thank you for that question. To be clear, I did not have information specifically provided by the ombudsman, either specific to the complaint or of a more general nature. But as I have described, if information is provided to us with, about an allegation, our role in terms supporting the management of governor and council appointees would be to assess the nature of the complaint and provide advice in terms of a review of a situation, an administrative review. The consideration could be to launching a third-party independent investigation, any of those opportunities, or as I previewed, to the appropriate police authorities if needed, would all be avenues that we would have considered in terms of providing advice on next steps.
Chair, do I have some?
Unfortunately, you don't.
Okay.
Merci, Monsieur Robillard. Monsieur Barcelou-Duval.
Thank you, Mr. Robillard. Mr. Barcelou-Duval. Ms. Sherman, to get back to my line of questioning earlier, I'm imagining myself in your position. I'm at the Privy Council. The Ombudsman went to see the Minister of Defense to share a situation regarding General Vance, who is the big boss of the Canadian Armed Forces. There are some serious allegations regarding sexual conduct. The ombudsman goes to see the minister. The minister says, I don't want to have anything to do with this. This is too sensitive. You speak to the ombudsman speaks to you. You ask for information. He says, I can't give you any more than what I've got, what I did, because I don't want to compromise the identity of the victim. And you say, well, we'll just close the books. We won't go any further because we don't have enough information. You do not think that is a critical situation, and that if the ombudsman has gone to see the minister and comes to see you, that he would be in a position to just judge the witness's credibility and the victim's credibility. That it's serious. I'm trying to just understand this. Why is it that people just say, okay, well, that's fine, and we won't go any further?
Thank you for the question. I understand the point you're making, and I have said that we do take concerns being raised very seriously. We want to make sure that those concerns are heard and acted on wherever possible. We do have to understand and respect the confidentiality of the process. So I think it is, first of all, the ombudsman had provided the person with options and was awaiting direction in terms of next steps. And from our
Madame Sherman, je
perspective,
comprends qu'on donner des.
I understand that that person was given some options, but I'm not talking about the individual. I'm not even talking about the victim here. I'm talking about the vice admiral. I'm talking you about the general. I'm talking about the big boss of our Canadian Armed Forces. It seems to me that above and beyond this victim, there's the issue of the integrity of the armed forces and of the senior management there. Is that not being taken seriously?
thank you. Yes, I think that is being taken seriously. And I think that can be said by virtue of the fact that as allegations, specific allegations have come forward, most recently, there are investigations underway. In 2018, we did not have specific information. I think it is fair to say that being aware of that is something that, in the context of
Merci.
managing.
Thank you. I understand.
Time is up. On to Mr. Garrison, please.
Thank you very much, Madam Chair. I just want to return to where I left off in the last round with Mr. Sherman on the question of national security. If you, in the course of your job, come across information that you believe might compromise national security for any of the GIC appointees, who would you report that to?
Thank you for that question. I think that if there's a couple of elements to that, you've positioned it as if I came across it. And so in that context, if I did come across specific information that related to a governor and council appointee that raised those kinds of concerns, I would speak with the clerk in terms of his responsibility with me for managing the conduct of GIC appointees and determination of next steps to be taken would be based on that conversation.
But you would not go directly to the National Security Advisor?
I think that would depend on the situation, on the context, on the specifics. It may be something that we would speak about together with the clerk. It would really depend on the specific situation.
And so in this specific case, was there or was there not a conversation with the National Security Advisor by either you or the clerk?
I think I can only speak for myself and in that respect, and I did not speak with the National Security Advisor. I want to clarify that I didn't have specific information. The Ombudsman had that specific information about an allegation.
Well, again, that impugns the integrity of the military ombudsman, who did say that there was a credible complaint, but we've already covered that ground.
May I just respond to that? I'm sorry, but you've said that, and I do not, Madam Chair, want to be seen to be impugning the former ombudsman. I was respecting the fact that he was respecting the confidentiality of the process, of the complainant, of his office. And so my only point is that he was not in a position, in his view, to provide me with information. And so I did not leave that conversation with information, with any documentation or specifics that would have enabled further action at that time.
Well,
I'm afraid time is up. On to Mr. Benson, please.
Thank you, Madam Chair, and thank you, witnesses, for being here today. Mrs. Sherman, I'm curious, in your conversations or in your dealings with the PMO, did you have any exchanges either by email or by conversation with Katie Telford on this subject?
I am not in a position, I think, to speak specifically about individual conversations. My conversations were with the clerk.
So I'm just going to ask you this. So know that you had no conversations with Katie Telford.
That would be correct.
Did you have any email exchanges or conversations with Elder Marquez on this subject?
Again, that would be information that is specific, and I'm not in a position to answer that based on the protection of personal information.
It's, we're just trying to find out who knew what and when they knew it, so
I
that
understand.
we know how the decisions are made here. So how about, did you have any emails, exchanges, or conversations with Azita Asterves on this subject?
Again, you have seen the emails that did take place between in terms of hearing about the allegations.
These are all people working for the government now and are part of the decision-making process. So we're just trying to get to the bottom of this. So I think if you talk to these people, you can say yes or no. Yes, you talked to them, or no, you didn't talk to them.
I think that you have seen that I did speak with individuals from the minister's office, and I have confirmed that I did speak with individuals in the prime minister's office.
I'd like to go and ask you. So we talked last time on the 19th of February, and we talked a little bit about General Vance's $50,000 pay raise. So I'd like to ask a few questions about that. Can you tell us who initiated the process to give the general a raise?
Thank you for that question. I think what I might do is just give a bit of an explanation of the process.
Well, who would is that the defense minister initiate that? Who initiates that?
It comes about through the annual performance management program, of which the CDS is one of the GICs to whom that applies. I can clarify that at the time the CDS was appointed, his salary was fixed at what we call the DM2 range. His salary is within the same compensation structure as deputy ministers, and that the fixing of his salary at the DM3 range was done in 2017, so 2 years into his position. Those determinations are made on the basis of the scope and complexity of an individual's responsibilities, their experience that they bring to the job and develop in the position, as well.
So are you saying that they're just they're just automatic? That they just happen on their own automatically, not initiated by anybody?
No, they don't happen automatically. It is through the performance management program where.
So would the defense minister be involved in that and in initiating this process?
The defense minister is consulted in terms of the performance management program for GIC appointees. He would not make that decision himself.
Yeah, and I apologize for interrupting, but do you know if Minister Sajan was consulted in this review?
The minister is consulted in the annual performance management program in respect of GIC appointees within his portfolio. I would like to clarify, though, just because I think this question has come up, and the public service, my responsibilities in terms of managing GIC appointees throughout their tenure, and in particular the performance management program, is that those annual reviews are the basis for salary adjustments, either in terms of level or progression through a salary range. And we also manage economic increases that are approved by the Governor and Council, often retroactively. So the minister is consulted through the performance management program. Many factors play into that. I have described that in my previous appearance. I'm happy to give more detail that might be helpful. But the decisions on the setting of the salary are managed, the minister himself does not make that decision. It goes through the annual process.
And his pay raise would have to go to cabinet for approval.
The salary increases, as I've mentioned, in terms of from one level to the next, economic increases and movement inside a salary range are approved by the Governor in Council. And that Governor and Council approval is basically, as you will have heard, the Governor General approving on the advice of Cabinet. Cabinet itself, and I should clarify, is not necessarily full cabinet at all points in time. It can be subcommittee.
All right, thank you. I've let it go as long as I could. We're a minute over time, but
thank you very much.
On to Mr. Spengeman, please.
Madam Chair, thank you very much. And I'd like to just join my colleague, Mr. Bagnall, in acknowledging that it's Purple Day, a day on which we amplify our efforts to raise awareness for epilepsy. I'd like to thank both of our witnesses, Ms. Sherman and Colonel Boland, for their service and for appearing today. Ms. Sherman, in a previous phase of my career, I had the privilege of serving in PCO. And I'm wondering if I could just ask you to back up for a minute. Canadians who are watching will be finding themselves periodically through this committee and other conversations in acronym land. We're talking about the DND, the CDS, PMO, and PCO. What is PCO, and why is it so important to have an independent, professional, impartial organization, a central policy planning agency, at this moment in the midst of an important question and investigation going forward?
Thank you, Madam Chair. I appreciate that question, and apologize if I am using acronyms randomly, or too frequently. The Privy Council Office is effectively the department for the Prime Minister. Our responsibilities are supporting the cabinet decision-making process that supports our system of government, and throughout, there are various parts of the Privy Council Office, of course, that are aligned with supporting the whole variety of cabinet decision-making processes. I won't go into those details, but as you've mentioned, our role in being nonpartisan professional public servants is that we are able to provide advice impartially and based on principles of good governance to the government of the day. We serve each government as they come into office, and we provide continuity in terms of the structure and operations of government. We provide advice and support to the government in managing and achieving the priorities that they bring to governing as duly elected representatives of Canadians. So our role is very important in that context in terms of providing the advice and support that will enable decision-making systems of government to function effectively.
Thanks very much, Ms. Chairman. And similarly, why is it so important in Canadian public administrative thought and practice that a minister or other elected officials do not drive, do not taint, are in no way involved in investigations of the kind that we're discussing today?
Thank you, Madam Chair. That is an important principle of Westminster government. The elected representatives do not carry out investigations and manage the details of those kinds of things because they are elected. The separation of their role from the independent and nonpartisan public service is important in ensuring ensuring independence, fairness, all of those principles that are necessary in terms of ensuring fair outcomes and procedural fairness for individuals through processes such as investigations.
Thank you very much, Ms. Sherman. Ms. Sherman, the committee is tasked with another very important issue that's as important, if not more important, as the issue we've been discussing for the last hour and a half, which is how to transition out of the culture that is currently prevalent in the Canadian Forces with respect to sexual misconduct. In a 2018 article, you've been described as a leading member of the civil service on Parliament Hill, and a quote here is that your daily jobs include attracting and retaining talent, fostering innovation within the bureaucracy, and you've spent a substantial amount of time at the Canada School of the Public Service prior to being appointed to your current position. And the terms like change management, change agent, challenge function are prevalent in Canadian administrative thought. What recommendations do you have for this committee to tackle the question of culture change in the Canadian Forces in a deeper, substantive way?
Thank you, Madam Chair, for that question. It's enormous, but I thank you. It raises very important issues. We know that change management is difficult in any context, and culture change in particular is challenging. My work in terms of the other part of my job, public service renewal, is very much about ensuring we have an organization in the public service that is up to the challenge, is agile, inclusive, and equipped, is the frame in which we think about change management. One of the most important things that I believe is certainly commitment from the top, but more importantly, the engagement of the people who are affected. And so I think when you're thinking about the Canadian Armed Forces, it is important. The voices that are being brought to bear now are providing a very important message. And one of those messages, and I think my work in terms of the Safe Workspaces initiative that we did in 2018 was that, you need to make sure you have the structures and processes in place, but you need to make sure they work for people. And you need to understand where, if there are barriers systemically to people coming forward, to some of those voices being heard, you need to make room for that conversation and act on the real experiences that people are having, and try to make sure that there is a way to adjust, adapt, and provide the structures and systems that support people.
All right, thank you very much. On to Madame Gallant, please.
Thank you, Madam Chair, and through you to the witness. Who made the decision not to involve the National Security Advisor in the allegation?
Thank you for that question. I would not, I guess, presume that there was an explicit decision not to involve the National Security Advisor. As I have mentioned, the situation we were in was that we did not have we did not have information that would have enabled further action. We wanted to be cognizant of the issue the Ombudsman had brought forward, and at the same time respect the confidentiality that was being accorded to the complainant. And so the decision in terms of next steps or what could be done was very much factored, taken into account those elements.
Thank you very much. Okay. So have you ever been asked to do a task such as this to get the information on allegations against a senior government official? Have you ever been asked that question before? Yes, just yes or no is okay.
Yes.
Okay. When you contacted Mr. Walburn on March 2nd, 2018, did you inform him of what the meeting was about?
Thank you, Madam Chair. My exchanges with Mr. Walborn on March 5th and 6th in particular, I think indicate that I was clear that I did want to do the follow-up based on his conversation with the minister, and that I was not clearly seeking any information that he would not be able to share, but that I was looking to understand the nature of the complaint.
Yeah, he was under the impression that you were calling him in on something else. Okay, so back to the question about having to do this, bring allegation against a senior government official before. So when that happened, when was it? And who instructed you to do that? We're just trying to understand the process. So when was it that you had to do that before, and who instructed you to do it?
Thank you for that question, Madam Chair. When I answered yes, I was answering in a fairly generic construct. As I've mentioned, my role in supporting the government in the context of managing GIC appointees does require me to have sensitive conversations with individuals at different points in time. That is, in fact, one of the important, one of the reasons that the confidentiality that we bring to bear is so important.
I understand that, but we wanted to know who, so we're not getting that information. And to what extent was the decision, now we're going back to 2018, March 2nd, 2018. So to what extent was the decision not to invest the allegation against the Chief of Defense Staff when it was officially reported to the PMO March 1st, have to do with the charges that were brought against Vice Admiral Norman 8 days later?
Madam Chair, I'm not sure I understand the question.
Let me clarify for you. So here we have the Chief of Defense Staff, allegations being brought against him on March 1st, 2018, brought to your attention, and a mere 8 days later, charges are brought forth against the Vice Chief of Defense Staff based on evidence that is no more substantial than the allegation. But in one case, the Vice Chief of Defense Staff is investigated, and investigation starts, but nothing for the Chief of Defense Staff. I'm trying to understand why there is a difference between how the two were treated.
Thank you, Madam Chair. I cannot speak to the situation with the Vice Chief of Defense Staff. I had no engagement in that at all, and I don't have information on that. And as I have mentioned, based on my conversation with the former ombudsman, I did not have information even about the nature of the complaint or specifics that would have enabled further action.
All right, thank you very much. On to Mr. Baker, please.
Thanks very much, Chair. Ms. Sherman, before I ask you my first question, I wanted to share something, reiterate something that I had said in our last committee meeting, where of course you were not present, Ms. Sherman, but the other committee members were. During that meeting, I think myself and a number of members went to great lengths to sort of highlight that what we think the victims of sexual assault and sexual harassment would want us to be talking about is how we move forward. And that was in the context of a discussion that we were having within the committee. But I wanted to highlight that subject again as we reflect on, as we get to the tail end of this meeting, because I think that this meeting reflects that we, for the most part, aren't doing that at all, and I think that's a shame. And I think we all have a duty to do that and should make that a priority going forward. So with that in mind, Ms. Sherman, I'm going to ask you a question which follows up on Mr. Spengeman's last question. He had asked you about culture change and how you approach that. At the tail end of your answer, you spoke to the need for certain structures to be put in place. I think that's where your time ended. And I'm wondering if you could elaborate on what kinds of structures you were referring to. If you could give some examples of that.
Thank you for the question and for your remarks. I think when I was speaking about structures and we often have policies, processes, frameworks that are constructed and intended to support the objective that they are designed that they are initially developed for. I think we do need to be, and particularly where we're looking for change, for innovation in how we actually manage within the public service, and that's not just in the context of complaints and harassment and workplace well-being, but we do need to make sure that those systems remain relevant and effective, and that and to get back to the safety and security of the workplace, if people are not comfortable coming forward, if there are, if there's fear of reprisal, all of the systems that we have in place aren't doing what we need them to do. And so my comment was really focused on understanding why that is. You can't proceed with change management if you may have an objective, but you need to also understand where you're coming from and why you aren't getting there. And so systems and structures need to be adapted based on the real experience of people who are trying to use them for the purposes for which they're intended. And when that's not working, we need to understand, we need to hear from people and figure out how better to develop and design those systems and structures.
Thank you. Chair, how much time do I have left?
Oh, a minute and a half.
Minute and a half. Okay. So, Mr. Chairman, just again, further on that line further on that topic, can you provide sort of examples of maybe something you've witnessed? I'm not necessarily asking you to comment specifically on the case of the Canadian Armed Forces or even the Canadian context at all, but I'm thinking about best practices, right? Like others have faced these challenges, other institutions, not just in Canada, but around the world, and have resolved them to some degree or to a great degree. I'm hoping to learn from that, and I think this committee needs to learn from that. Are there best practices that you have seen, examples of best practices that you have seen that we should review?
Thank you for that question as well. We certainly can always learn from others. One of the things that we do try to focus in on in terms of innovation in the public service is not reinventing the wheel and taking good practices from others. And in some cases, we know they exist within the public service. And then we looked at those and we think about scaling up in terms of something that has worked well in one situation might be applicable to another. Innovation is certainly a theme and an underlying principle of the change we're trying to achieve. I think in terms of best practices, I'll keep coming back to what we call in the public service renewal world, the user experience. And so when there are examples of departments who have, for example, looked at how their call centers run. And in dropped calls and client dissatisfaction and people not getting the answers they need and waiting too long on the phone, there are instances where a particular department or agency has taken that apart and looked at what's happening and put out a challenge, for example, to different groups to say, how can we fix this? What are the issues?
Thank you. Thank you very much.
That process. Thank you.
Thank you, Mr. Chairman.
On to Monsieur Barcelou-Duval, s'il vous plaît.
Merci, Madame la Présidente.
Thank you, Madam Chair. Ms. Sherman, the defense minister so far has stated that if he had decided to act or to meet with the ombudsman to hear the information that he wanted to share with the defense minister, that would have been encroachment. Would you agree with that assertion?
Sorry, thank you for the question, Madam Chair. I don't think I'm not an expert I'm not a lawyer, and I'm not in a position to provide a view on a legal concept such as that.
OK.
Okay. And let's say the Minister of National Defense, you are trained in public administration, you have a high-level position. For the defense minister to meet with the ombudsman who has evidence of a concerning situation to share with the defense minister, do you think that is encroachment?
I'm not sure what the question is. Encroachment of what? Maybe an issue of translation. I apologize, but I'm not sure what you mean in terms of encroachment of what.
En fait, je fais essentiellement référence.
I'm essentially referring to the minister's comments. I'm very surprised, given that you have a lot of experience in the public service. I think that could be useful to us. The former ombudsman, it's not interference or encroachment, according to Commander Leblanc at the Canadian Forces. He also thinks that's not interference or encroachment. He may have received some information from the Privy Council office not to. Is that what was recommended to him?
Thank you for that clarification. And no, when I would say we had not provided any advice or information to the minister when he met with Mr. Walborn. My understanding of that meeting is that they had a discussion, and this is from the testimony to date. They had a discussion themselves, and we would not have provided advice in advance of that.
De conseils ni d'instructions.
So you provided no.
I have to be strict because we're coming to the end of our time. On to you, Mr. Garrison, please.
Thank you very much, Madam Chair. I want to go back to Ms. Sherman. I want to say first directly to you and for the record that none of my questions today have as their intent to impugn your integrity or your record of public service. I have the utmost respect for that. And as I said, I think it's unfortunate both the Prime Minister and the Minister referred the committee to you. But I do think what your testimony reveals today is a parallel to the culture of denial and deflection in the Canadian Armed Forces, and also one which we heard from Lieutenant Colonel Boland today about deflection and denial within DND. And the parallel here seems to be that the privacy of the accuser seems to be much more important than responding effectively to the complaints of sexual misconduct. With regard to Mr. Baker's comments that the committee is not actually pursuing a solution, I beg to differ. What I have heard very distinctly from those who have filed formal complaints and many who have not is that what they want to know is that there's an understanding at the top level of what sexual misconduct is, and that there's a commitment that there will be effective action taken on those complaints. And without that confidence, we're left with a program like Operation Honor, which failed precisely because it didn't have that understanding and support at the highest levels. So, Ms. Sherman, let me go back then and say, once you had reported to the clerk of the Privy Council that you could not proceed, and I won't dispute with you again whether or not you could have, was there any reason that the Minister of Defense or the Prime Minister would have believed there was an investigation on taking place into the sexual misconduct allegations that were presented by the military ombudsman?
If that, may I clarify, in 2018?
Yes.
Not that I am aware of.
And was there any response to the Privy Council office from the minister or from the Prime Minister asking that any further action be taken?
I would not be in a position to respond to that in terms of the confidence of advice and further discussions internally.
All
So
right, thank you very much. I'm afraid, Mr. Bazan, please.
Thank you, Madam Chair. I want to go back to Privy Council office. We know that on May the 9th, General Vance was moved up from Deputy Minister 2 to Deputy Minister 3 through an order in council, giving him a $50,000 pay raise, plus it was backdated to April of 2018. We also know that there was 34 total order in council signed on May the 9th. Does that, Mr. Chairman, suggest this was done in front of a full cabinet meeting?
Thank you for the question. No, it doesn't. And I would just clarify that the numbers that you're referring to in terms of the salary ranges, the change for General Vance from a DM2 to a DM3 was effective in July of 2017.
Okay, it still happened under the current government.
Correct.
Just so there was 4 ministers that signed off on his order in council. Can you tell us which 4 ministers signed the order in council to increase his salary and move him up to a DM3?
I cannot. I do not
apply that information to committee through a reply to a written request. The other part of this is that the Prime Minister's office is listed as one that's responsible for the department of actually signing off on that order in council as well. Can you confirm that the Prime Minister signed that order in council on May the 9th, 2018 or 2019?
I am not in a position to confirm that information, and I believe it would be a cabinet confidence. But I will respond as
it's a public
requested.
Document. We'd like to see that document, please, if you could provide that to committee. Now, the Minister of National Defense said on March 12th that he has no overview of performance reviews or performance pay, but you said that ministers are part of the performance review process. So if the minister didn't do it, then did he abrogate his responsibility to actually do the performance review of General Vance?
Thank you for that question. I think it's an important opportunity to clarify a little bit. The performance management program, as I said, and as is posted on our website, does involve ministers being consulted about the GIC appointees within their portfolio. So
he would have been consulted.
So in the performance management process, but I believe there is a distinction in terms of the actual decision on the change in pay, the awarding of the performance, the pay at risk under the performance management program, that those are managed through my office and preparing to the Governor and Council. So ministers do not set the pay.
Yeah, so if you're setting that pay and you were aware of the allegations against General Vance, did you at all write a report to go on the file of General Vance and raise the red flag that there's sexual misconduct allegations against him before you recommended him for a pay raise?
Again, if I can clarify, we make recommendations to the Governor and Council in respect of those pay changes in pay, the setting of pay on an annual basis. I do not make the decisions myself as a public servant.
So would you have put in his file a red flag saying that there was sexual misconduct allegations?
That would
so
be
that could be considered when order and council met to determine whether or not there was a salary increase that was warranted?
The personal information of an individual in their performance review process. The performance review process takes into account all aspects of performance, leadership, management, the corporate responsibility, the corporate commitments across the government. So there are various elements, and an allegation or the existence of an allegation or an investigation that is going on would not be. It would be taken into account in the context of an ongoing investigation.
Can you confirm that there is red flags in General Vance's file
cannot,
dating back to 2015 and 2018?
I cannot confirm the details of personal information in a person's file.
All right, thank you very much. On to Madame Vandenbeld, please.
Yes, thank you very much, Ms. Sherman, and I want to thank you for your many years of public service and for your testimony here today. I'd just like to clarify usually in your testimony that depending on what the results would have been that you were to find out, you could have launched a third-party investigation. You could have referred even to the military police or to any other sources. And ultimately, you could have removed the Chief of Defense Staff because it's a GIC appointment. So is it safe to say then that when it comes to an allegation like this, your office, the Privy Council office, was the proper independent authority?
Thank you, Madam Chair. As I have described our role, we do provide independent, nonpartisan, professional public service advice to support ministers and the Prime Minister in managing the GIC cadre, particular appointees where issues arise. And so it is something that we would have worked either with the portfolio in any of those avenues you've described, investigation or otherwise, to ensure that kind of follow-up was done.
Thank you. And so, I mean, you obviously can't talk about it, and you, of course, didn't know at the time, but we have heard through media reporting that the evidence in question was actually an email, a suggestive, inappropriate email from 2012. Had the recipient of that email provided the ombudsperson with permission to share that email with you, would you then have taken that further?
Thank you for the question. It is difficult to speculate on things that didn't happen. I will speak to generalities in terms of the process that we can undertake. When information is brought forward and we have facts and details to look at, we would take the appropriate action, as I have mentioned, in assessing how to best proceed with such information to help with the management of the GIC appointee in question.
And you mentioned in your testimony today that you wanted to do follow-up and that the ombudsperson had actually given the complainant other avenues. Do you know what those avenues were, and do you know whether the ombudsman actually went back to the complainant to let her know that that PCO wanted to investigate and wanted to do follow-up?
Thank you. I am not aware of what the ombudsman would have done following our conversation.
Okay, and would it be appropriate in something like this where you have somebody who has not given consent to release the email in question or any information, whatever it might be, would it then be appropriate to go to the person who is allegedly the perpetrator and alert that person, tip them off that somebody was complaining about them, or would that actually violate the consent of the individual, assuming that the person might be able to figure out who it was?
Thank you, Madam Chair. That is an important consideration. As I have spoken about, apply to how we manage issues of conduct of a GIC appointee, have to take that into consideration. The wishes of the person who is affected or is bringing that forward, and also the inability to provide any details to the respondent, the potential respondent, would be a matter of concern as well. So it's very difficult, depend on the specific situation, but in general, we do take the wishes of the complainant into account.
So would you say that the real concern, the real issue here is, I mean, we had a situation where the person didn't want to come forward with very little ability then to follow up, is the fact that people are afraid to come forward, that there is still a culture, there's still a fear of reprisal. Would you say that that's what we ran into here, is this larger cultural issue of people being afraid to put their names forward? And would you say that, what kinds of ideas would you have in terms of how we actually fix that?
Thank you for that question. I don't have enough information on the specific situation that Mr. Walborn raised to make that kind of an assessment. I have said, and I guess I would repeat, that we do need to find a way to make sure that people will come forward, and whether it's fear of reprisal, whether it's concern about how broadly that information might be shared, we need to make sure that we do have independent, safe spaces for people to come forward to.
All right, thank you very much. And I would like to express our thanks to the entire committee's thanks for our witnesses today. You've provided very important testimony. And is the committee, are we good to adjourn? Yes? Okay. Meeting adjourned.